Well, welcome, welcome, welcome. Welcome to the second Monday Q&A, but it's the fourth one. So yeah, just welcome to everybody. Normally we do these on the second Monday of every month. And because of, a whole lot of events going on in June, it just seemed best to wait until later in the month when things were hopefully quite so busy. And then two is that we typically go dark in July. So we thought this would be a nice midpoint between our one for May and then the one coming up in August. So do mark your calendars for the second Monday in August. We'll be back on our regular schedule. And I'm Dr. Deborah Dupree, so I'm delighted to be here today. And with me is Felicia Menta, freshly returned from a long trip.
Yes, I had a very exciting adventure trip for 2 weeks. Longest vacation I've taken in 15 years working for the JPA. So.
Yeah, well, great. Well, it's nice to have you back, and thank you so much. So we did a little bit of preparation, I think, both pre and during her absence. And so we promised you 4 key topics today. And again, we try to focus on what we call hot topics, things that we're actually experiencing in the school districts or things that are happening, new developments in the law. And so because we've been ending up one year, and for many of you, you're getting ready to start a new year just around the corner. And for some of you, then it'll be coming a little bit later in the summer. But last time we did talk about, good ways to wrap up your school year. Now today, one of our topics will be how to get ready for your school year. So let's, Felicia, give them some highlights of the 4 key topics that we promised them for today.
We're going to talk about how excessive absences can affect instructional staff and impact a district's compliance. We're going to talk about that. We're going to talk about the timing of doing an IPM when employees getting close to the 100 days of half or subpay doc for instructional staff. We're going to talk about what does it cost a district when they miss the 60-day time frame to schedule an IPM and make an offer to return to work or not. And again, talk about what's coming up very soon is back to school. Even though we're just winding up from getting out of school, I have noticed, Deborah, that the hiring under the pre-placement physical and drug testing program is just going straight up like this. So we are hiring at all levels, all staff for all of our member school districts.
Yes, it is a busy time of year, and we're also trying to take our vacations, right?
Yes.
Yes. Well, let's go ahead and get started then. And I wanted to address the first one. When high absenteeism starts to impact the district's compliance with state guidelines, particularly around individualized education plans. And this is actually based on a couple of recent interactive process meetings that I've facilitated. And one of the things, before I go into some of the details about that, of course, without disclosing any names, but one of the things that I do encourage all of you to keep in mind that absenteeism is a strong indicator, if not the strongest indicator, that we have a medical condition going on. Houston, we have a problem. And yet I am continually surprised, and I've been working with the JPA now for starting to approach 8 years. Yeah. And the high numbers of employees who have been out for extensive absences and seem to go unchecked. And I know, we get into a little bit of a quandary with the education code's provision for the 100 days annually for the classified employees, where it's only one time for the certificated. But one thing I'll just say is that if you're in a situation where you have employees who have high rates of absenteeism, first and foremost, be aware that if they are not working 2/3 of their contracted hours in the prior year to the current year that they want FMLA protection, they're not covered. So by FMLA, the ability to have your job protected when you can't work is the threshold. You have to work 2/3 of your contracted hours. And so if somebody, like I've been dealing with one employee, so there's 2 cases I have to talk about. One employee who for almost 4 years has only worked about 50% of the time. And
Wow.
so what miraculously happens, she enters into the 100 days and then ends up returning. And so I'll share with you how we're managing that for this year, because we've tried 3 different forms of accommodation, and she still is experiencing, high absenteeism, 8 absences in a little over 2 weeks, or 3 weeks. And we even tried a later start time. We tried reduced hours and reduced job responsibilities, and attendance still hasn't improved. And so at this point, she is going into the 100 days. And before she can come back to work, even if she presents a note, she's going to be put into a functional capacities evaluation. Okay, so that's not one where it affects IEPs, but it does, it particularly straps the department, which is responsible for all kinds of purchase orders and payments to vendors and major, maintenance projects and things like that. And so they've been grappling for this for almost 4 years. And so we feel like we finally have a plan of action going into place. But the other one that's come up, well, actually we've had 2, where again, an employee has had high rates of absenteeism, and again, was sort of left unchecked. There was some change in the people who manage the interactive process at this particular school district, so they were still getting their feet wet, shall we say. But one of the things to also keep in mind that the EEOC, Equal Employment Opportunity Commission, has said in the past that employers do not have to accommodate unpredictable and unexpected attendance, because attendance is one of the conditions of employment, an essential function. And so, and I see lots of cases, though, of where there's unpredictable, unexpected attendance, which then, leaves the district grappling, particularly if there's lack of timely notice, which oftentimes there's not timely notice. So grappling to find qualified substitutes to fill in unexpected, unpredictable absences, and particularly difficult then in the special education arena, where you need, uniquely qualified individuals, either as a teacher or as an instructional assistant, to meet those needs. And so what we had encountered, and quite frankly, I mean, I even told the employee this, and I said, it's not your employer's responsibility to remind you of what these things are. You've been an employee here for over 10 years. And so if you don't know your employment requirements and, when to report, how to report, and things like that, Houston, we have a problem. And so it's a combination of, he reports a medical condition, has not reported any medical treatment, though. I'll come back to that. And what has happened then is that they have documentation. That's one of the things I frequently ask for before, when we know we have an issue about attendance, is please produce your attendance records for the last 3 years. Because this employee says, well, I've never had a problem before. And it's like, well, that's not what the records show. And again, it wasn't reporting timely. People really didn't know where he was. And as a result, the students that he was assigned to serve were actually not getting the required instructional guidance required by their IEPs. And this actually puts the district into a non-compliance with state guidelines about the delivery of IEPs, and could result in financial fines, as well as other, potential interventions that the state may impose upon the district. So please, please, please watch, if you've got employees with high rates of attendance, it always needs to be looked at, because of how it can create an undue burden for the employer. But in this case, in another case I'm working on, it actually puts the district out of compliance in another area that impacts students. And so that's another form of undue hardship, because now students are being adversely impacted because of this employee's medical condition and his inability to be at work, stay at work, and perform the work.
And one of the things we've seen, Deborah, you and I have both seen a few cases like this at some small districts and a large district, is where the excessive absenteeism has been going on for a while. But, and I know the one case, it's sort of anxiety, mental health condition, didn't come into the comp world until almost exhausting the 100 days, running out of time, right? Running out of leave. And now it's being filed as comp claim. And then we're, kind of straddling both issues, the excessive absenteeism, and a lot of union reps do tell our employees that if they file a comp claim, it will keep them from the discipline process and from running through their time and going on 39 months. This is not true.
No.
This is sometimes what they're told.
Yes, thank you for bringing that up because, yeah, unfortunately, not all union reps are as well versed as they probably should be, since they're in the role of guiding their union rep members. And unfortunately, in each of these cases I just mentioned, union reps were involved, and they both spoke up and saying, "Oh, we have a real problem, Houston. Non-compliance with state guidelines for IEPs, we can't support that." And so they sort of had a talking to their member as well. And in another situation too, again, the chronicity of the absenteeism was just so great. And it's like, again, if we go to other federal standards, it's like you're not even meeting the thresholds that you're capable of working. And they've already brought her back, and I said, no, in this case, if she, because of the history, if she attempts to return with a new medical note, an FCE, effectual capacities evaluation, will definitely be necessary, but also an interactive process. Yeah. So in a way, Felicia, I think that might be a good segue to the other one that we talked about with IPMs and someone in the 39-month rehire.
Yeah,
So,
so that does lead into that, the timing of doing an IPM when someone's approaching the end of their 100 days. What does that mean? And then one of our districts asked if we could also address, can you also cover doing an IPM for employees that are already on a 39-month rehire?
yes, absolutely. Yeah, for those of you who have used me, in my summaries, I always say this IPM may be a one-time event, or we may come back to the IPM process to address any changes in the employee's medical condition, or in a change in business practices. Those are the two conditions for when we may need to revisit an accommodation. And so both situations, in fact, I've got a couple right now where people have already been in the 39-month rehire, want to come back to work. But again, it's what changes there been in the medical condition. And in one case, we actually were able to offer the employee an alternative job. She's been off on 39-month already for several months. And because there had been a change in her condition, and there was work available, and we know that there's been a shortage of employees, she was made the offer. Now she came back wanting a different shift, and she wanted a different location. She's like, well, no, that's not how it works. You're offered what's available. And so so we went ahead and made the offer. She had the right to decline it if she didn't want to accept the offer of hours and location, but then she has a right to decline it. Well, if she declines it and it meets the conditions under workers' compensation, then she does not get the supplemental job displacement voucher. And so we had to guide her on that, and you have the option, but here's what we have to offer. And so in that particular case, it was a change in medical circumstances that brought us back to the table.
One of the things I wanted to add too is, as a best practice, a lot of times we're notifying them that they're running out of their 100 days. HR is notifying them, or risk is notifying them by a letter, you're going to run out of your 100 days by X date. And perhaps they're going to hit their July 1 rollover, and perhaps they're not. And if they're instructional, maybe they're just doing their 5 months one time. When they're nearing the end, we always recommend, even if you do not have an MMI report from either the treating physician, the QME, or an AME outlining any permanent work restrictions, we do recommend as a best practice that you go ahead and gather up all the work restrictions that you do have, and that you try to hold a meeting before they run out and go on 39-month, either on your own or with the assistance of our contracted provider, Dr. Dupree, because what that does is set the stage. So maybe they're not MMI yet, but we do know that they've been out for a very long time, because if they're running out of all leave, they've been off for a long time, right, Deborah? Because it takes a long time to go through all this leave inflated with the workers' comp TD 2/3. And I think it's important that you're communicating, right? We're not only sending the
Yes.
letter, you're running out of time, but we're talking about what your options are, what's going to happen to your benefits, what's going to happen to your pay. These things are vital to our employees, right?
Absolutely, absolutely. And I can't echo enough the importance of communication. And, both you and Felicia and I have been doing this for many, many years. And what I've learned as being a facilitator of the IPM, that when we maintain good communication, even if we think we know what the outcome is going to be, we actually reduce the potential for post-termination litigation, either in the workers' comp system or in the civil side, on the employment side. And because we've taken the time to not only explain to them how all this works, but then also we also take the opportunity to say, well, check into CalPERS disability retirement, check into state disability income if you're medically unable to work, check into Social Security disability income, you may be potentially eligible. We don't know those answers, but at least we're letting them know. And I can't tell you.
Right. And talk to your claims examiner about your permanent
Exactly.
disability and potential settlement and or your attorney if you have one, right?
Right, absolutely. Because a lot of people, as I like to say, is that, until you have a medical condition or until you have an employee who has a medical condition, most people have no idea of all of these, benefits and services and opportunities to support somebody through their recovery until they're actually in it. And so many people have expressed surprise. I had no idea. I had no idea all these things were out there. And it gives them some hope that even though their job, their physical presence on the job site may be ending, that doesn't mean their employment status necessarily ends yet. And it doesn't mean that they're suddenly penniless, that there are these different forms of benefits available, but they have to go out and do their own work to find those.
And I believe that lack of communication leads to why IPMs sometimes with multiple union reps are so emotionally charged, right? Whether they're done on Zoom or in person, they can get very emotional. And I think a lot of that is because the employee is just shocked. They had no idea that this was coming. And to answer the one district's question, can you also go over doing an IPM for an employee that's already on 39-month? We kind of discussed this in one of our prior JPA work comp training meetings when we went over the Keenan jury verdict. I think it was over $30 million, Deborah, and the school district paid $1 million to settle before the trial went to the jury verdict. It's really important. I think Jennifer Creighton, one of our JPA panel attorneys on the civil side on employment law and property and liability, had a very interesting comment. And Deborah, you might be able to quote it more accurately, but she was saying it's better to think about an employee on 39-month as an employee that's in an unpaid status because the high rights to rehire are so high. And I've heard many districts when I say, oh, they're MMI, here's the permanent work restrictions, and that are sent over from the claims administrator because our TPA sends over the work restrictions from either the MMI report from the primary treater, from the QME, or from an AME, or from all of them, so that the district has all of the work restrictions available to do the meeting. A lot of districts will write back and say, oh, they're on 39-month. We don't need to meet with them. We don't need to discuss this with them at all. And I'm always concerned because I think, wait a minute, they're sort of like they're gone, right? We don't owe them any rights. We don't owe them any meeting. And this is kind of what happened in the Keenan litigation case. So I didn't know, Deborah, if you wanted to add some comments to that. So.
Yeah. And thank you so much for that opportunity. And that's where, one, if they're, just to reiterate what you said already, Felicia, is that one, if they're approaching the 100 days, and preferably, not at the very end, but, maybe 60 to 75 days exhausted, but to have that meeting, just sort of say, where are you, what's going on, because here are the next steps. And so you're keeping them informed. And again, it goes a long way to any post litigation, that potential. The second thing then is in the 39-month rehire is that technically they're still unemployed. They're not entitled to their same job, and that's also a mistaken notion. They're in an unpaid status. They no longer have access to the same job, but they're still eligible to apply for any future opening for which they qualify and be given sort of priority rights. They don't have to compete for it as a new job applicant. And so that's the other thing is for those of you who handle your employees with medical conditions is don't forget about those people in 39 months. If you see openings that come up, make sure that you're doing a check against your list of 39-month employees. And again, reaching out in a good faith effort to let them know that there are some opportunities. And that's one thing I always tell employees too, is that it's your responsibility at this point to primarily stay on top of openings. And you notify HR if you see something that you feel you're interested in and feel qualified to do. Because sometimes employees do go on to use the workers' comp displacement voucher to get retraining, and they may have acquired new skills that make them eligible for employment in some other capacity. And so, don't dismiss those who are in 39 months and say you don't have to do an IPM.
Right.
You're in grave danger if you.
Well, it cost Santa Cruz $1 million.
Exactly.
Right. $1 million they paid to settle that case before it went to trial. Right.
Right.
That leads so well into our next point was, what does it cost districts when you miss the workers' compensation 60-day time frame from the permanent and stationary or maximum medical improvement status, and the employee might still be working, right?
Yeah. Yep.
So.
Yeah, that's a really good one. And because of the Keenan case that did go to trial last, I think it was September of 2022. So it's not that long ago, not even a year old. Felicia mentioned that the Santa Cruz district actually paid out $1 million from their own coffers. That's not even what Keenan had to pay out. And so this got to be a very expensive case. It was Jennifer Creighton again did an excellent job of presenting on this last fall at your fall workshop, Felicia. And so the thing is that it's really tightened up now. It used to be, I have to admit, a little loosey-goosey prior to the Keenan case, but now, again, once somebody is at MMI status by Division of Workers' Compensation guidelines, you as an employer have 60 calendar days, 60, to determine whether or not you can offer modified, alternative, or if the employee is actually going back to regular work. And so it's imperative that you get that IPM scheduled, and particularly if the employee is still working, because we need to establish, okay, the employee may be working, but sometimes the work restrictions that we get in the MMI status report, the employee doesn't know about, the employer doesn't know about. And so it's important that we review them to make sure everybody understands, okay, these are long-term limitations now. And is there any impact on performing the essential functions of the job, or do modifications need to be made, or are there risk factors? And so if an employee is working and you don't hold the IPM within that 60-day time frame, TPA must still provide the supplemental job displacement voucher to the employee, even if they're still working. So that could be a tune of, well, the employee gets $5,000, right? And plus a computer, plus the money towards books, and then the training facility gets $6,000.
Yeah, so I did some research because you're right, I know the broad strokes about the supplemental job displacement voucher, but I wanted to be more detailed for this, because I know we record it for those that can't attend and they listen in later. So the supplemental job displacement benefit, it's available for injured employees who have, number one, you have to have permanent disability as a result of your injury. If you don't have any permanent disability, you're not eligible. Number two, you have to be injured after 1/1/2004. That's when it kind of came into being.
Right.
Number three, you have not been offered other work by your employer, right? That's important. That can also be a reason you're not qualified for it. And it comes in the form, it's not like a check for $6,000 the TPA sends to the injured employee. That's not how it works. It comes in the form of a non-transferable voucher that can be used to pay for education, retraining, or skill enhancement at state approved or accredited schools. You just can't go use it anywhere. And the injured employee receives the $6,000 from the claims administrator, and the 60 days is from when the claims administrator receives the report. We have gone back and forth on whether it's the date of the report or it's the receipt of the report. But I went and looked on the California website, and it is 60 days from when the TPA or our JPA panel attorney, if they receive the report, whoever received the report first, because it has to be date stamped in, we have to prove these dates. It's 60 days from that time. And it can also be used, to your point, Deborah, to buy a computer up to $1,000 out of this voucher. It can be used for a reimbursement of up to $500 for miscellaneous expenses, and you can use up to $600 for a vocational consultant, like your prior career, Dr. Dupree, to use for counseling services to help you find a job. I will say that anecdotally, not very many people use the voucher. We send a lot of people vouchers because the districts have a hard time. We have many cases where we've had to pay the voucher just because the district hasn't been able to get everyone together and hold the IPM. Sometimes they hold the IPN after the 60 days and they make a job offer. All right, Deborah, we've seen this pipe now, but the TPA still has to pay the $6,000 voucher, even if you do that. That's just because we missed our time frame. It's very strict.
Yeah. Well, and I appreciate what you had to say as far as, we've sort of gone back and forth on this because I think originally it was the date of the medical MMI report, but because, particularly if it was a QME in the workers' comp system, we may not get the report for 30, 45, 60 days. And so that's where they shifted it to when the claims examiner is notified, or like you say, legal counsel is notified of that date. Then it's imperative that we start taking action, getting the IPM schedule and addressing this. And one of the things I'll say too is that now I've got on my IPM request form is that when did you receive the report? Not only what's the date of the report, but when did you receive the report? So that way we can calendar when those 60 days are up and we make sure that we have met within those guidelines. So school districts, you would saving yourself lots of money by being proactive. And I like to say, the IPM might cost $600 for the meeting. However, you get documentation from that, and $600 is sure a lot cheaper than $6,000.
Well, and we have a few districts right now that have kind of an interesting situation. They had the IPM, they made an offer. It's alternative job. The one that we have going on right now with a pretty large district, they made an offer of an alternative job that's at a different work site. And the employee is not very interested, right? They want to work at the site where they were originally injured. And so I kind of went and reread what the job offer has to contain in order to pay the voucher. And it says, number one, you have the ability to perform the job, the essential functions of the job. That's number one. Number two, the job is a regular position lasting at least 12 months. Number three, the job offers wages of compensation that are at least 85% of those paid at the time of the injury. And number four, the job is located within a reasonable commuting distance of your residence on the date of injury. So for this district, what the claims team said, claims administrator said, we're not going to offer the voucher in this case because you offered an alternative job that we think is in a reasonable commuting distance. The employee does not. And if they don't accept the position, our position is we don't owe a voucher. If they litigate, then we'll discuss it. Obviously, it's something that we can discuss. And what's going to get discussed, that reasonable commuting distance. What is that? What does that mean? There's no 10 miles, 50 miles. What she is saying, the new site where the alternative job is not as close as where she was working at the date of injury. It's not that far, right? It's a slight distance of maybe 10 to 20 miles. So because of this last little bullet point, we're not absolutely certain whether we're taking the position we don't owe the voucher. The TPA is, but it's possible that we might have to pay the voucher if there's litigation over that. What is a reasonable commuting distance? I just wanted to add that because that's kind of an interesting case we have going on now.
Yeah, yeah. Thank you. Because there are two points about those criteria for what's a viable modified or alternative job. Is that not only the commuting distance, and I'll share with you what I believe to be the ADA just to give people some reference, but then also a comparable shift. And so my understanding from when the DWC notice was originated is it was like if you were taking somebody from a day shift to a night shift or a
Mhm,
night shift to a day shift, then that's what's considered not reasonable. And because
mhm,
that's a very, very different thing.
mhm,
However, if it's like a daytime shift, like in the recent case I had, where she didn't want to work she was working early morning hours, the nutrition
mhm.
services, and the offer was for a noontime campus
Right.
supervisor, from like 11 to 2 or 11 to 1 or
Mhm,
something like that. And so, but the wages were comparable, and et cetera. No, and then that's what I said is I think, this is the different shift is it's reasonable, still a daytime shift, and if anything, better commuting times too. And then for the distance, I would have to double check this, and so I will, but with my recall of what the ADA has said in the past is a reasonable commute is within 60 miles. Okay. Now I've also heard some reference to 30 miles because it's not
hmm.
unusual that people do commute,
Right.
quite a long time, and
Mhm.
so I'll have to do a little research into that piece of it then. But 30 miles is not considered an unreasonable commute. But it's all a matter of perspective. And if it's within your school district, it should be within a reasonable
Should be
commute.
within a reasonable commute, right?
Yeah,
Because it's
yeah.
not that broad of an area. And it is interesting. The other case that I was thinking of, Deborah, and you'll recognize this one, is the employee came to the IPM, an alternative position was offered, and then they sent a letter offer of return to work of that alternative position. It is not the position the person was doing at the time of the injury. They didn't answer at the time of the meeting, and they haven't responded since the letter offer went out. And so their question to our TPA, to Athens, was, do we have to pay the voucher, right? And so I looked that up too. And so the employee may qualify for the voucher unless the employer offers the job, the employee rejects it, or fails to accept it, the modified work lasting at least 12 months. So even if they fail to respond, that's still considered rejection and the voucher doesn't have to be paid, if that's helpful.
Right. Right. The DWC notice also says that the employee, like the employer, has 60 days to evaluate their ability to offer a modified alternative. The employee technically has 30 days from the date it's presented to accept it. And then again, if there's failure to accept it within that 30-day time frame, that's considered a rejection.
Right. Because the
Yeah.
district was sort of like, what do we do now? Right. Like it's just up
Mm-hmm.
in the air. How long do we keep the job open? Because we've offered the job. And so you're right, there has to be some timeframes around that because, and then the voucher also, one of the other things I was looking up, it expires. So it expires after 2 years from being issued. So it's not like it's just an open-ended, we pay the voucher and you can go to training whenever you want to. So it does last for a while, but as I said, anecdotally, we just don't have a lot of people that take advantage. They get the voucher, but a lot of people don't ever go to the training and they don't request the money for a computer and the tools and the counseling that they're
Yeah.
entitled to. So
Yeah. Yeah.
interesting to note.
Yeah, I know. I found that interesting too,
Mhm.
Felicia, when I've looked into that, surprising how many people don't
Mhm.
take advantage of basically free money, to get some new job skills, get a computer and things like that.
Well, and I was reading that if you were injured after 2013, on the state's website, that employees who have received a supplemental job displacement voucher, they can also apply for a one-time $5,000 payment. And they have to apply to the state return to work program. And then it has to be approved, but they'll send them a $5,000 check. So there's, kind of rich benefits around this return to
Hmm.
work program. It's not a 4-year degree, but there are some benefits, but a lot of times our employees don't take advantage of them.
Yeah, yeah, yeah. So very, very interesting dynamics as far as employees who are out there for a long time or have exhausted their 100 days and then again, the value of an IPM. What I would again suggest to our participants and listeners that an interactive process meeting can do so much to protect your liability on so many levels, and that it's sort of like it's what why do it? It's sort of like why not do it? Because you address so many different laws, so many different timeframes, and again, it's one way of maintaining a healthier employee-employer relationship, as well as basically your district status. Because if employees feel that they've been treated well, they'll speak well. If employees
Mhm,
feel they've been treated poorly, they'll speak poorly.
mhm.
So then there goes your reputation as a good place to work.
And that's a good segue into it's that time of year again for our back to school just around the corner.
Right, right. And so, I know basically a lot of our participants and listeners, are year-round employees, and so you get a little bit of a lull, so to speak, in terms of
Mhm,
the active employee engagement. But this would be a time to, take a look at your employees who you have on medical conditions and or maybe out on extended leave or absentee problems. So you might need to coordinate with payroll and things like that. I'm working with another, somewhat small but mid-sized school district, and they have some new people who are now into their human resources and business office area,
mhm,
and so they were trying to get a handle on just who's out there. They asked me who I'd done IPMs on, but it was a very, maybe less than 10 in a couple of
mhm,
years. On the other hand, when they went to their TPA, they got a list of 50
mhm,
employees who were off on some kind of medical status and some very significant sums of money associated with their workers' compensation claims and et cetera. And so this would be a good opportunity to be able to take a look at who's on, who's off, and how can we manage this? Because there can be huge savings to a
mhm.
district when well managed on their return to work programs. And so that's what I would suggest is, getting ready for the new school year. Here's a
Mhm.
great time, and start getting those IPMs scheduled so that you can take a look at how do we, because again, this, how do we get them back to work? How do we keep them working? And how do they perform all the essential functions? And so,
And from a work comp perspective, what we really recommend is that you have Athens, or that you pull off of your Sims network, because you can run your own reports too. But Athens is happy to do it for you. Also, all of your employees that are off work currently on work comp temporary TD 2/3, because we want to take a look at those folks before the start of the school year to make sure that we have the most up-to-date notes, because we don't want people coming back to work on the school year who have been off through the end of the prior school year without a note. We don't want them just walking onto campus and we don't know if they're supposed to be on some kind of modifications or they have work restrictions. So you should be one by one going over all of those people that are off work now, so that you can make sure you get an updated note before the start of the school in August, so that you're up to date on their medical conditions. And like Deborah said, if you need to meet, that you go ahead and do that before the start of the school year. Because what you do not want is people that have been off work for an extended time and you don't have an updated medical status, and they're just going to start the school year, without you knowing exactly where they're at.
yes, yes. And to add to that, Felicia, is that if you have employees who have been on so-called temporary modified or alternative work, that should not be automatically carried over into the new school year either. Again, we like to offer temporary modified or alternative work when medically appropriate, but also if the work is actually available. And if
Right.
the work's not available, then we don't have anything to offer. And even though the doctor may say that someone can engage in modified work, again, it's always a balance. What does the employee need and
Mhm,
capable of, and what does the employer need in order to deliver on their business services? And that's where we can get into
mhm,
danger again, going back to these students with individualized education programs. How does the employee's condition impact the delivery of services in our students getting the required services necessary at any level, but particularly with IEPs because of the other state requirements.
And I think it's really important to remember too, that if they are on temporary accommodated duty, that you're looking at your return to work program, a lot of injured employees assume that they're going to go back to that temporary modified job at the start of the school year, but it is just that, temporary. And so someone needs to be counting under the return to work program and communicating where you're at with that, because maybe they're not eligible for that temporary modified duty in the fall. And you don't want to be having that discussion when they show up to work on the first day. Anybody that's that's working on temporary modified duty before the end of the school year, you want to take a look at them before the school year starts too, to see where they're at. Same thing with their medical condition and under your return to work program with your timeframes.
Absolutely, absolutely. And just on that note, I'll add, because there have been a shortage of employees, what I've seen some districts start doing, and this is long considered a best practice in the interactive process overall scheme of things, is to even have a job bank of job like departments where they routinely need some assistance, and they could benefit for somebody filling in or assisting, not a regular job per se, but they could always use assistance. And that's a perfect place to put somebody for 60 days to see if they recover and or get better. And but then again, it requires monitoring. But that way you're helping out other departments. And so I know a lot of like human resources has been doing that, particularly as they have been emerging from COVID conditions and continuing to digitalize their records and things like that. And so, but again, be mindful of not letting it go on too long. This typical duration of temporary modified alternative work is 60 days plus 60 days, and that's 60.
We have principals that made a job bank in the return to work program, the JPA return to work program. I think it's on the third to last page or somewhere around there. And it's like 2 or 3 pages of temporary modified work that, or temporary alternative work, whatever word you want to use for that, light duty, modified duty, it's called lots of things, different kinds of tasks that might work. And then, Grossmont, Sean and Kathleen that run their return to work program, they have particular, I don't know, Deborah, it's like, there's like 5 or 6 different jobs that are set aside for injured employees to do when they're hurt. Jobs that are relatively easy that they can put injured employees in. So they kind of have slots for them already. So it's hard to do that at a smaller district, but if you're mid-size or larger, and now right now with all the openings, with the amount of hiring that everyone's doing everywhere for everything, obviously that's where a lot of people look and get creative about putting their injured employees if they're qualified and if they can perform those jobs.
Right. Yeah, and on that note too, because I have seen a relatively small school district be very creative with an employee who was a custodian and then couldn't do that work anymore, but they needed help because they were digitalizing all of their records. And she was able to actually help out at the district office as well as the school site where she had been a custodian, but in the office setting because they needed help. And so be creative, think outside the box. And this is where, better to pay people for productive work than paying them disability benefits for sitting at home. So this is a win-win for the district.
We offer file reviews to all of our members every 6 months or more often if they would like them. And we were doing an in-person file review last week with Athens. And it came up that this person was off work because there was no temporary modified duty available at the district. This is a pretty large district. And the HR folks said, we're doing a huge scanning and shredding project right now. I could use this person, like in the meeting, they said that. So, but you know what happened? This person's a custodian and the supervisor in that department said, we can't use them. There's nothing for them to do. And in risk, that's not where you should stop, or HR. That should not be that should not be the stop to you of, oh no, sorry, you can't come back to work. We don't have temporary modified duty. You should be way more creative than that. They can work in other departments. They can work under their supervisors. They can work at different sites. You don't just have to rely on that department supervisor to see whether or not you can utilize that person.
Yeah. Yep. And on that note, I know I keep saying on that note, another note, and then we'll wrap up here. But if you are putting someone into a temporary alternative position or a modified position, maybe at reduced hours, um, then they would still, they haven't lost their job classification. They haven't lost their rate of pay. It's temporary. And so, for example, I had actually, this is our third IPM we just had last week, and the employee has a pattern of not being able to work more than 50% because of a medical condition, and it's been very unpredictable, unexpected. They've been, coping with it, grappling with it, hoping she's get better. We tried part-time, we reduced her schedule to see if that wouldn't help her sort of get on top of things a little bit. And then her doctor released her to full-time work. So she went back to full-time work. And then over the, January, February, March, April, May, again, increased absenteeism, not even 50%. And so in May, we agreed to, we had a better understanding of her stressors and what was going on. And so they were able to offer her a part-time, later start, because getting to work on time was an issue, a later start, reduce hourly schedule so she could better attend to her medical appointments, and then a job that didn't have the level of job responsibility that her usual job. But she, remained at her usual pay. And so it was only if she was moved permanently into that position would she actually undergo a job reclassification and then go to the lower pay. But unfortunately for her is that her attendance didn't improve even with all of those considerations. So right now she's going on an extended leave of absence to see if she can't get on top of her medical condition.
Right.
Yeah. So, well, very good. Well, thank you so much, everyone who attended today. And, I hope you found these hot topics as interesting as we have, because we deal with these things all the time, but hopefully gain some insight on how to more effectively and efficiently manage some of the challenges you come up with and, moving on. So I see Carla has a hand up. So go ahead and unmute yourself.
Clapping, I think. I think it was a thank you, I think.
Okay. Thank you very much, Carla. I appreciate your use of the hand gestures. Yes. Okay. Well, again, for a reminder for everybody, the recording of today's program will be available usually in 7 to 10 working days. And so do share it, pass it on. And this is a, public service event. We charge nothing for it except for our time and your commitment. And the idea is just to enhance our knowledge and understanding of medical conditions in the workplace. We are going dark in July, so there will be no meeting. And then we'll be resuming on the second Friday of August. And we hope to see you all there.
Yes, it's wonderful. Enjoy your summer.
Yes, have a great summer, everyone. Take care.